Hi, Assalamualaikum to our beloved lecturer. We are from Group 6. Will present our article review. Introduction. The problem faced by Islamic banks is to impose penalties on late payments, as there are differing views by Sharia scholars on whether or not to impose the penalty will amount to usury. In the context of Islamic banking, financial penalty is recognized as a late payment charge encompassing two elements, namely ta'wid and gharamah. Therefore, we will discuss the issues of late payment charges involving the practical use of ta'wid and gharamah in Islamic banking in Malaysia.
In Malaysia, the regulatory framework can be set up by using the Sharia Advisory Council (SAC), the issue on practicing ta'wid, gharamah, negligent factor, and notice upon default. The gharamah is about the late payment charges by the debtor to the financier or to the banker. The ta'wid is about compensation based on actual loss or late payment. Both of them is to remind customer to pay on time because it acts as psychological deterrence tactics. For the negligent factor is the late payment charges that imposed to the negligent customer. And the last one is notice upon default. It is about the late payment charges must be informed about the fees to the customer at least 21 days based on the operational requirement by guideline of the Bank Negara Malaysia.
Okay, new findings or significant information to the field for Islamic banking and financial system. First is implementation of late payment charges in Islamic financial institution in Malaysia. According to Bank Negara Malaysia, Sharia resolution in Islamic financials 2010, ta'wid is a claim for compensation arising from actual losses suffered by the financier because of a late payment of financing or amount owed by the customer, whereas gharamah is a penalty charge imposed for late financing or debt settlement without the need to prove the actual loss suffered. There are four justifications. The first is delay in loan payment as well as financing without reason will be detrimental to creditors. The second is late payment without reason is also seen to consume property interest and the third is the only way to compensate and eliminate damage due to late payment. And last, the law of fines only focuses on debtors who have the financial ability to compensate and losses caused by their negligence.
The next new finding in the article is risk management. Risk management is one of the central elements of an Islamic bank to prevent default by customers and protect the establishment from running out of its stored assets. Conventional banks will be presented with risks such as credit risk, market risk, liquidity risk, operational risk, regulatory risk, and reputational risk, while Islamic banks will be presented with additional risks such as Sharia inconsistent risk, process risk, and counterparty risk. This will make Islamic financial transactions more dangerous than conventional financial transactions. Conventional banks will be used yield charge on late installments. However, Islamic banks do not do so, and this allowing Bank Islamic to be exposed to more significant credit risks. This risk can be mitigated by applying Rule 78, which is that early repayment will be involve a larger share of income than each month thereafter refunds. This is due to the fact that if a user defaults in the early years, financial institution can, however, recover a definite quantity of income other than the base quantity. For domestic or land financing, even if the collateral provided under the agreement allows Islamic banks to take back and sell the underlying property at a modern market fee to cover losses, The market the value of fixed goods in the early years may not be good enough to cover a great quantity as it will take time.
So let's move to the relevant issues related to Islamic banking and financial system, which is Gharamah. Controversy on permissibility persists. Despite the fact that the SAC has decided that both Ta'wid and Gharamah are permissible by Islamic banks in Malaysia, and the BNM has given recommendations for implementation, it appears that only Ta'wid is widely used. Because of the fundamental character of riba, barriers in setting up separate charity accounts, and transparency requirements and law related with it, most Islamic banks choose not to implement Gharamah. This may have led to Malaysian and Middle Eastern scholars' unanimity on the permissibility of Ta'wid, but continue disagreements on the permissibility of imposing Gharamah.
Second issue is Ta'wid, actual composition or opportunity cost. Taking Ta'wid as amount that may be compensated to Islamic banking in situation based on actual loss incurred due to default as defined by the BNM guideline on late payment charges for Islamic banking in situation. This paper finds it anomalous that late payment charges are imposed in cases where there is no judgment. This is because unless a judgment is rendered, the actual loss incurred has not to be accounted, only the opportunity cost. This is due to the fact that bank risk management department and mitigation mechanism are not developed in the case of late payment, but are already in place as part of normal banking operation. The establishment of a risk mitigation or recovery department, as well as the action taken to remind customer to make payment through phone call or letter, are all part of the bank operational costs from the start and are usually included in the financing facility provided to the customer among other price components. This means that it is the bank responsibility to remind clients when payment are due, usually through the risk department or the collection department staff. Only a court can determine whether the customer was careless and whether the default case resulted in actual direct or indirect costs. As a result, the statement in the Sharia Advisory Council resolution that Islamic financial institution will suffer actual loss in terms of incurring additional expenditure, such as a cost for issuing notice and letters, legal fees, and other related costs, is inaccurate because there is no additional cost. To put in another way, both the Ta'wid and Gharamah, in my opinion, do not cover any associated costs and instead serve as a psychology deterrence approach to remind customer to pay on time.
Overall, the article helps us to understand the subject of Ta'wids and Gharamah in Islamic banking in Malaysia. From our viewpoint, Ta'wids and Gharamah imposition has caused difficulties to people. This is because the application of Ta'wids and Gharamah is not in line with Islamic banking basic rules, which are to facilitate people. It is essential for Islamic banks to differentiate between delinquent debtors and the one who really have difficulties in repaying at present due to the hardship in their lives, so that the basic rules of Islamic banking could be met. The authors also suggest for Islamic bank to use Rahnon and Kafalah contract as alternative to recover from the loss of late payment from the customers. Therefore, if Islamic banks' implementations are not according to principle of Islam, then the institution might damage their credibility and trust from people.
Based on the article, Islamic banks must devise a new strategy that considers the Quranic prescriptions for dealing with customers. Islamic banks are advised to come up with a new ideas and try a different approach to handling the situation, instead of imposing a penalty for late payment. Another recommendation is people must be taught excellent morals, norms, and disciplines, like paying their debt as quickly as possible without deferring payment on purpose. Last but not least, banks should keep their Gharamah accounts separate from their Ta'wid accounts
to enable proper administration and governance.